Flammorschale Fokusstrategie, Dienstag, 18. Januar 2022. Jetzt kommt da auch noch Folgendes. Separate and dissenting opinion. Judge MacDonald. The presiding judge, Gabrielle Kirk MacDonald, found, however, to the contrary. She concluded that at all times relevant to the indictment, the armed conflict in Obstina Prijedor was international in character, that the victims were Judge MacDonald, that the victims were protected persons and that Article 2 was applicable. In her separate and dissenting opinion, Judge MacDonald notes that the majority purports to apply the essence of the test in the Nicaragua case. The standard crafted by the majority, however, departs from Nicaragua. The standard the majority has created is even more demanding. According to the judge, there are two bases on which the acts of the VRS could be attributed to the FRY, where the VRS acted as an agent of the FRY, which could be established by a finding of dependency on the one side and control on the other, or whether the VRS was specifically charged by the FRY to carry out a particular act on behalf of FRY, thereby making the act itself attributable to the FRY. In Nicaragua, the court required a showing of effective control for this latter determination. While finding that the evidence presented to the trial chamber supports a finding of effective control of the VRS by the FRY in Obstina Prijedor at all times relevant to the charges in the indictment, Judge MacDonald states that the appropriate test of agency from Nicaragua is one of dependency and control, and the showing of effective control is not required. According to Judge MacDonald, the evidence supports a finding beyond a reasonable doubt that the VRS acted as an agent of the FRY. In regard to the attack and occupation of Obstina Prijedor during the times relevant to the charges in the indictment, and the victims are those protected persons, the dependency of the VRS on and the exercise of control by the FRY support this finding of agency under either the majority standard of effective control or under the more general test of dependency and control. The evidence proves that the creation of the VRS was a legal fiction. The only changes made after the 15 May 1992 Security Council resolution were the transfer of the troops, the establishment of a main staff of the VRS, and the change in the insignia. There remained the same weapons, the same equipment, the same officers, the same commanders, largely the same troops, the same logistics centers, the same infrastructure, the same source of payments, the same goals and mission, the same tactics and the same operations. Importantly, the objectives remained the same: to create an ethnically pure Serb state by uniting Serbs in Bosnia and Herzegovina and extending the state from the FRY to the Croatian Krajina along the important logistics and supply line that went through Obstina Prijedor, thereby necessitating the expulsion of the non-Serb population of the Obstina. Although there is little evidence that the VRS was formally under the command of Belgrade after 19 May 1992, the VRS clearly continued to operate as an integrated and instrumental part of the Serbian war effort. This finding is supported by evidence that every VRS unit had been a unit in the GNA. The command and staffs remained virtually the same after the redesignation. In addition, the evidence established that the VRS, in continuing the GNA operation to take over Obstina Prijedor, executed the military operation for the benefit of the FRY. According to Judge MacDonald, the evidence supports a finding that despite the purported GNA withdrawal from Bosnia and Herzegovina on 19 May 1992, active elements of what had been the GNA and was now rechristened as the VG operated in tandem with the VRS. So, there was a connection between GNA and VRS, and then the GNA, there was a transformation from GNA to VG, and this liaison or this connection between GNA and VRS, it was transferred to VG and VRS. In fact, perhaps here there are the same persons or the same institutions, GNA and VG. The name changed, perhaps even some people changed. But it was the same connection between GNA and VRS, and then VG and VRS. So again, VG operated in tandem with the VRS in Bosnia and Herzegovina. In particular, VG air crews and aircraft remained in Bosnia and Herzegovina after the purported May withdrawal and worked with the VRS throughout 1992 and 1993. This and other evidence provides that there was no material change in the armed forces in Obstina Prijedor, and that the conflict remained international after 19 May 1992, with the FRY exercising effective control of the operations of the VRS in Obstina Prijedor. Regarding the relationship between the VRS Commander General Ratko Mladic and the VG main staff in Belgrade, Judge MacDonald finds that it is enough that General Mladic, who had been a commander in the GNA, continued to carry out his orders, which were issued by the FRY before 19 May 1992, considering the evidence that established that there was direct communication between his office and Belgrade. Regarding the majority's finding that the FRY and the VRS were allies, and thus that there was no effective control, Judge MacDonald finds that this supports rather than vitiates the statutes of the VRS as an agent. The judge concludes, I question why there should be a requirement that effective control was in fact exercised when the FRY was assured that, having transferred officers and enlisted men and provided the material, thereby depleting its forces, its plan would be executed. The occupation of Obstina Prijedor could be accomplished only after the GNA, on behalf of the FRY, set it in motion and gave the VRS the wherewithal to accomplish it. The wherewithal to accomplish it. Under such circumstances, there was no need for effective control. However, because the very establishment and continued existence of the VRS is evidence of such control, the key issue here is whether the VRS was indeed dependent on and controlled by the FRY. In summary, the evidence supports a finding beyond reasonable doubt that the VRS acted as an agent of the FRY in regard to the attack and occupation of Obstina Prijedor during the times relevant to the charges in the indictment, and the victims are thus protected persons. The dependency of the VRS on and the exercise of control by the FRY support this finding of agency under either the majority standard of effective control or under the more general test of dependency and control. However, a close reading of Nicaragua leads me to conclude that the effective control standard supports a distinct and separate basis for the attribution of the conduct of non-agents to a state, and that it is not a necessary element for a finding of an agency relationship. So that is the Tadic case, the verdict. Then there exists another document. Then there are several documents, but another short document, also press releases. Duško Tadic sentenced to 20 years imprisonment.